Mr. Gogoi, in one matter yesterday, day before yesterday, you got it? No. There was an order being passed by me where I've asked you to get an inquiry done through the SP Gulaghat. What has happened is, along with the copy of the petition, what has happened, the petitioner number, the respondent number, there are two claim petitions which were filed. The first claim petition was filed at Golaghat. The second was filed here. First was filed in the name of one person. The second was filed also in the name of that person along with another, whereby the second person's name, who was the claimant in the earlier proceedings, is different. Now, what has happened when the matter has come up against the same incident? Matter has come up, now the counsel appearing on behalf of respondent number 1 and 2 now here says it is now respondent number 2 and 3 are one and the same person, although their addresses are different. So therefore to inquire, because otherwise if I send it one matter to one court, it would have a consequence.
My lord, I did some item number 7. But in this case,
Who are you?
my lord, I am for the petitioner, my lord. And the learned senior counsel, my lord, Kane Chaudhary sir is representing the petitioner, my lord. And my lord, he has some difficulty today, my lord. He is contesting in the bar election today, my lord.
Huh?
Kane Chaudhary sir is contesting the bar election today, my lord. Yeah,
Where's the forest?
I have informed.
Forest has no objection. The request of the learned counsel for the petitioner, the matter stands adjourned to 2nd of September 2024. Interim order passed earlier shall continue till then.
After vacation, my lord.
Isn't it 2nd of September after vacation?
My lord, sorry, my lord, the month of July.
No. I remember this case. You have been taking time right, left and center every time.
No, my lord,
Therefore, Mr. Kane Chaudhary is fighting some election. I am helping you out. Otherwise, this is not there. You don't seem to be in urgency. There's no urgency. Then first of all, I don't grant adjournment on the ground of the senior counsel. Then in that case, if you have urgency, I'm not going to adjourn it. Okay? Take your risk. 2nd of September or today. You don't have a case unless you get your thing amended out there from the order.
It's clarified.
That has been clarified.
Yes. Clarified. It's clarified.
Did you file an additional affidavit?
Then you have obtained the copies, my lord. If
Bring it by way of an
Yes,
But 2nd of September it is.
my lord, in the month of August,
Today or 2nd of September.
file the PDF.
Today or 2nd of September. Whatever you feel like, do. Next. But how much is the delay? Oh, no object. We'll see when the matter is called.
I beg to mention item number 46, my lord.
Huh?
Item number 46, the other side, my lord. But,
What is that matter about?
I am not.
Don't make a mention.
P.K. Roy Chaudhary, my lord, is reading the case, my lord.
Next.
And his mother-in-law, very serious, my lord, that is why.
We'll see when the matter is there. At that point of time, you make a mention. Let's see.
Please mention item 35, my lord, with the consent of the other side. I'm appealing for the appellant here, my lord. My difficulty is that, my lord, that I have not been able to establish communication with the appellant, my lord.
Fantastic.
Only therefore I pray for 15 days time so that I can serve him with a notice, my lord. Otherwise,
Or what?
For my lord, I'll withdraw my wakalatnam otherwise.
Why?
I'm not being able to establish any communication. I do not know what state, whether they have.
What is the
compromised my lord.
35? What is the item? It's the RSA.
No, my lord, it's an FAO, my lord.
FAO will dispose it of. FAO is a small matter. Yes. Next.
Please, my lord. Otherwise, my lord,
You know, you were engaged. So FAO is against an interim order. So,
not passing of an interim order. But I prayed for ex parte ad interim injunction, which is not granted.
so therefore, nothing remains. Let us see when the matter comes.
My lord.
Don't.
Yeah, please, your lordship. I'm appearing on behalf of Mr. M.D. Bhuyan. I am adjournment for today, item number 16 and 17.
What is that?
Order, item number 16, I am for the appellant, and item number 17, I am for the respondent number 2.
So, it has come up for orders. We'll see. We'll make a mention. Next item 1.
On promotion.
AC2 23. Yes.
May I please, Your Lordship?
Transfer from where to where?
Your Lordship, this is a transfer petition filed for transfer of a TS, which is pending before the Honorable District and Session Court, Kokrajhar to Bongaigaon, Your Lordship.
Oh, nearby.
Your Lordship, there are some network problems which you can mention in the petition, Your Lordship.
Bongaigaon and Kokrajhar is just across the street.
Yes, Your Lordship.
Then,
There are some reasons for which this
Huh?
petition filed, Your Lordship. There are some reasons, Your Lordship. for
what
which-
are the reasons?
Your Lordship, the petitioner, an unemployed lady, Your Lordship.
So what?
She has 2 minor children.
How much is the distance? How much? Kokrajhar and Bongaigaon, how much?
About 50 kilometers, Your
Oh.
Lordship. And she is an unemployed lady, Your
You
Lordship.
stay in Sipasila Sila
Yes, Your Lordship.
in Bongaigaon district.
Your Lordship, there is another case pending before the Honorable District and Session Judge Bongaigaon.
What is pending?
Another maintenance case, which has been filed earlier before filing this restitution case, Your Lordship.
So what?
Pending before the Honorable District and
When is the next date?
next day. Last date was, Your Lordship, 21/6, Your Lordship, the next date will be.
What happened? You appeared pursuant on 28/5. You appeared. Now, then it became 21/6. Then, file your written statement. Then we'll look into it. They are not going to stay.
Your Lordship, another case is pending before the Honorable.
So what? How does it matter if it is
Yes,
pending or
based
not?
on, and she hasn't
That is that the
testified.
125 proceedings. 125 proceedings is not before the same court. Want that I should issue a notice only.
State,
Absolutely no. Doing. No stay business. When is the next date?
28/6.
28/6. Oh, file your written statement. I'm not staying it. Then we'll consider then. Issue notice making it returnable on 5th of August 2024. Steps be taken by way of registered as well as usual upon the respondent within 3 days. The learned counsel appearing on behalf of the petitioner has sought for an interim order that the further proceedings of title suit TSR 04/2024 be stayed. This court is not inclined to do so. it has also been informed that on 28/6/2024 is the next date fixed before the learned trial court. The petitioner herein would be well advised to file their written statement. Full stop. The further continuation of the proceedings. Full stop. It is, however, observed that on the returnable date, subject to service being meted out, on a returnable date, this court shall consider about the interim prayer.
Go to
Please, your lordship.
Transfer from
Transfer from my lord, Principal Judge Family Court Nalbari to my lord, Principal Judge Family Court Kamrup Metro, my lord. Why, my lord, I'd like to say, my lord, that, the marriage of the petitioner, my lord, solemnized at Guwahati, my lord, on 1/3/2021. Thereafter, their special marriage was also, before the marriage officer Kamrup Metro, my lord, in 11/21, my lord. Thereafter, my lord, after a few days of their marriage, they came out of the matrimonial home and took a rented place at Adabari for their job purpose, my lord, at Kamrup. Thereafter, my lord, got pregnant, my lord, at after gave birth to 2 twin baby girls, my lord, on 22/12/22. However, my lord, the respondent deserted the petitioner, my lord, on 23/8/22, my lord. I have stated that at paragraph 9, my lord. And thereafter, he left the petitioner, my lord, and never came back, my lord. Only on the day of the delivery, my lord, he came once, my lord. Then thereafter, he walked away, my lord. And now, my lord, thereafter, having financial crisis, my lord,
who? You?
the petitioner, my lord.
Why?
Although she is working in, my lord, as a block coordinator, my lord, Poshan Up. She is working as a block coordinator, my lord,
Where?
in Poshan Abhiyan scheme, my lord, social welfare department on a contractual basis, and which gets renewed every year, my lord.
How much is she earning?
Earning about 20,000 per month. The person, my lord, the respondent, already a DV case has been instituted at JMFC Kamrup Met, wherein an interim order, my lord, in the favor of the petitioner has been given, my lord.
The
She's,
issue notice
That
available on
annexure 4, my lord,
7th of August 2024. Steps be taken upon by way of
Report,
registered as well as usual.
my-
File an affidavit of at court at Nalbari. But the principal judge, family court Nalbari, does not have the jurisdiction in the divorce,
yes, my lord, divorce petition.
in the divorce proceedings, taking into account the marriage between and the respondent to. Also, they last resided at Guwahati. That view of the matter, this court is the further proceedings of title suit. Title transfer of matrimonial suit bracket D, case number 1024. Currently pending before the principal judge, family court Nalbari.
Your lordship.
Yes, what are you challenging?
the interim order at case.
Yes,
Lordship, case 58 is the.
we're challenging the order of 25/2/2024.
Lordship.
What is that?
At case Lordship 58.
What is that?
petitioner filed a petition for including the original vendor under order with the lordship that was rejected. The lordship will find the
Whom do you want to make them a party?
lordship the original vendor.
Huh?
Original vendor from whom the father of this present petitioner was given lease.
What is the stage of the suit?
Lordship, necessary orders, necessary orders.
No. What was the stage of the suit? Yes, what is wrong with the order?
The original vendor is the.
No. First of all, Mr. Counsel, tell me one thing. You want to implead them. Fantastic. But have you amended your plaint?
We are the defendant, lordship.
Huh?
We are the defendant.
You are the defendants. Why are you before this court?
Lordship, the petitioner being defendant filed a petition before
Who filed that application?
the petitioners being defendant for impleading the original vendors. of
So
the
the
suit claim.
defendants won, somebody else will be made a party in that suit.
Lordship, the original vendor,
What is this? I thought that you were the plaintiff.
dependent.
Well, how can you implead somebody in the suit of somebody else?
If lease was given by the vendors in favor of the father of this present petitioner, 1994 for a period of 30 years. During that lease, collision of the vendor and the plaintiff's husband, so they made a sale deed in favor of the plaintiff. But that the plaintiff filed this civil suit for eviction of the petitioner's father. And after the petitioner's father death, these petitioners are included as defendant.
You have a counterclaim.
Lordship. It is Lordship 26. Lordship, paragraph 14,
You have not challenged the sale deed. For declaration that the raise is fraudulent, inoperative, illegal, and not binding on the defendant. Don't you think that without him being made a party, how can you file a counterclaim? See, for that, you are saying that the sale deed executed by the vendor of the plaintiff is illegal and fraudulent. Isn't that your case? But that vendor is not a party to the suit.
no,
So are you not therefore challenging the vendor's authority to do so? If you are doing so, can you file it in your counterclaim against anybody else who is not a party to the suit?
we have taken plea in our WS at page 34, Lordship. In
That is what I am saying, page 36. You couldn't have filed the counterclaim.
Page 34, paragraph 14, Lordship.
That I have seen it. Now, what is your stand?
Is the vendor of the necessary parties of the suit. So, by
Whom do you want to make? Abdul Ahid?
no, Lordship, the Aftab, these members of the Dola family, Lordship.
Huh?
Moniruddollah, Muktabuddollah, and Aftabdollah.
Where is your allegation out here against these people? No.
In paragraph 3 of my petition, Lordship.
The plaintiff in collusion with her husband so-and-so in respect of the so-and-so suppressing the facts and so-and-so. The plaintiff in collusion with her husband Abdul Ahid got the sale deed in question registered fraudulently by playing fraud upon so-and-so, so-and-so. There's no allegation against these people. You want to make Aftabdullah, Moinuddinullah, and Muktabdullah. There's no allegation against them.
I have to-
Where?
Stated in paragraph 3, Lordship.
Where is that allegation against them? Read it.
The petitioner said that their late father, being defendant of the aforesaid title suit, filed his written statement from counterclaim on 12/11/2007, stating that the suit is false, vexatious, and fraudulent, and the same is liable to be dismissed. The defendant in paragraph 5 of the written statement stated that the respondent plaintiff in collusion of her husband Abdullah Ahad and the vendors have got the sale deed in respect of the suit land and registered fraudulently by concealing the real fact that the suit land is free from encumbrances. But in fact, it is encumbered much prior to the alleged sale of the suit land. In fact, the vendors, namely Muhammad Aftabdullah, Muhammad Moniruddollah, and Muhammad
No allegation against these people. I would have understood. You want to make the counterclaim against somebody. But first of all, can you have a counterclaim against somebody who is not a party to the suit? See, then why did you file the counterclaim at all if you wanted these people out there? You can't add them. See, Order 8, Rule 6A. See the language used. A defendant in a suit may, in addition to his right of pleading a set-off under Rule 6, set up by way of counterclaim against the claim of the plaintiff any right or claim in respect of a cause of action accruing to the defendant against the plaintiff, either before or after the filing of the suit, but before the defendant has delivered his defense or being time barred. Now, if you see the judgment of the Supreme Court in the case of 1992, 3 SCC, if I'm not wrong. Think the learned trial court is right. What makes a person a necessary party is not merely that he has relevant evidence to give on some questions involved. That would only make him a necessary witness. It is not merely that he has an interest in the correct solution of some question involved and has thought of relevant arguments to advance. The only reason which makes it necessary to make a person a party to an action is that he should be bound by the result of the action, and the question to be settled therefore must be a question in the action which cannot be effectually and completely settled unless he is a party. This is the law. Dismiss. But better you advise to withdraw this counterclaim and file a suit if you want. Where at the end of the day, you may have you want to do it because tomorrow you may say in the suit, they may raise an issue out there that look here, he has made this a party and they have not made a party. The allegations are being made. These are the vendors who have executed. So unless you don't challenge it, may be a difficult. Now, this will give you a good reason for withdrawal of the counterclaim. Yes. The learned counsel appearing on behalf of the petitioner submits that he would not like to further press the instant proceeding, which have been filed challenging the order dated 15 to 2024, passed in Midzi case number 104/2023, arising out of title suit number
133.
133,
Lordship.
isn't it?
Lordship.
133/2007. Good stuff. Taking into account the above, the instant petition stands just on withdrawal.
Obliged.
Yes, Mr. Samaria.
Small prayer, my
Whom
lord.
would you want to put
A
behind
village, my
bars?
lord, running from pillar to pole, get the, my lord, MSCT award amount, enhanced amount, page 23, my lord. If possible, at least issue the notice, they will release the amount, my lord.
Huh?
Page 23, my lord.
Fine, insurance directed to deposit the amount of rupees demand and This is a local adalat.
No, my lord, it was contested, my lord. Thereafter, my lord, we approached before this honorable court, enhanced amount was given. Now,
Oh,
in
he has,
presence of, my lord,
that was in a stay.
Hello?
There was a stay order.
No, no, my lord,
this has been disposed of.
Uh,
There is a award against which we approached before the enhancement. Little amount was enhanced. The principal amount they have deposited to the tribunal, but the rest amount and interest has not been deposited in terms of the direction to the registry, my lord. This direction was passed in presence of the council of that insurance company, my lord.
Hello. Yes. You have written a letter to this
Yes,
person?
yes, page 24, 25.
How do you know this person was there?
My lord, the regional my lord manager, because the
Because
party.
the 24 is to some United India Insurance Company.
Yes, my lord. The
Regional office, Chibber House, GS Road.
The regional office, my lord.
And then to the general manager. He is the general manager.
My lord,
Then we are written to the general manager and how
my
the
lord, the
regional
general
chief.
manager, actually what happened, my lord, this segment particular of religion that has been dealt with particular person, but office has been represented by regional manager, my lord. And regional manager ultimately, my lord, kindly see page 23, there is a party, my lord. Page 23.
Ah.
United India Insurance Company regional office. Therefore, it has to be dependent on the head of the person, my lord.
Understood. But here, why we are writing it to the
My lord,
general
yes, my lord.
manager
General manager, what happened, my lord? We have approached to the concerned
and
person.
giving the address as regional office?
My lord, no doubt, my lord, in regional office, this particular person dealing with the subject matter.
Has this been received?
Yes, my lord. There is
How do you know?
there is a receipt, my lord. Page 27, downside.
15th of June 2023. And the first one?
First one, my lord, also we have, my lord, the receipt is there. Page 24, downside.
Okay, issue notice returnable on 12th of August 2024 steps where I registered as well as usual within 3 days. Who is the appellant in this SAO? Not necessary. This is against what? Remand. So there is no substantial question of law required. We dispose of that. I'm just tracing out all SAOs and disposing. of.
But it's not, fine. But
No, it can't be. Because you see, this is under 104.
that's fine.
Second appeal is 100. So does 104 conceive of any substantial question of law? The court has framed it. I won't notice it.
The lawsuit have to hear the matter. Today,
Yes, let us hear.
today the.
We'll tell, we'll see. What is this? Why, what is the order passed? Mr. Roy, these type of matters has to be finished on the first day itself. Every day nowadays, whenever on one Thursday, or I take up ask them all the here. This is a 2012 matter. It can't remain like this. Now let us see what it is. And why it has remained is because of the fault made by this court, with due respect to the judge, of framing substantial question of law, which is absolutely unheard of. No, we finished now.
I was not prepared for.
Not necessary. I am also trying to do it, yes.
I will kindly have a look.
On concern, I find that a party should So where are the issues of limitation? Yes, on fraud and limitation. Limitation, kindly come page 63. Now, there was a prayer made by the plaintiff that this decree should be set aside on the ground that it is fraud and collusive. Kindly come to page 17. E and C. C.
My prayer.
Yes, that's your relief which we have sought for. B and C. Now, why this was no issue framed here?
Trial court has dealt with it because parties have that evidence on fraud and that evidence or deed of parties have that evidence to that effect, and the trial court has dealt with that. But the parties have that evidence, knowing fully well the issue.
Let's see how does the trial court decide on the issue of fraud of the judgment. Where is it? At page 36. Page 36 only. This is the what? No, merely dealing it without any evidence, nothing has been said. Where? No, understood. But how is the evidence taken by the learned trial court? And where is the question of limitation? How is the limitation question there? Because it is otherwise the bounden duty of the learned trial court to do in view of section 3. We dismiss the appeal. Immediately this should be continued by the trial. Heard Mr. P.K. Roy, the learned counsel, senior counsel, assisted by Mr. S.K. Chakraborty, the learned counsel appearing on behalf of the appellant. Appellants. And Mr. You are there?
I am a performer response. That is in support of them.
Who is there for the respondents? Anybody from the respondents? So appearing on behalf of the private respondents and Mr. T.R. Gogoi appearing on behalf of the government respondent. M.H. Rajbal Bhuiya appears on behalf of the performer respondent.
Performer responded 23, 4 and 5 man.
This is an appeal under Order 43, Rule 1U of the Code of Civil Procedure 1908, for short, the Code, challenging the order dated 30/12/2012, passed in title appeal number 39/2008, whereby the learned trial court, First Appellate Court, had remanded the suit back to the learned trial court to decide afresh by framing two additional issues. The legality and validity of the said impugned the order dated 33/2012 has been questioned in the instant appeal on the ground that though those issues have been framed, but those issues were very much substantive, were very much subsumed in issue number 5, and the learned trial court have duly discussed the same in while dealing with issue number 5. In addition to that, Mr. P.K. Roy, the learned senior counsel, further submits that the parties have also knowingly adduced and had knowingly adduced evidence about had knowingly involvement of the issue as regards the legality and validity of the judgment and decree passed in title suit number 62/76, had adduced evidence, and as such, the remanding of the suit by the learned First Appellate Court was contrary to the provisions of Order 41, Rule 24 of the Code. Ms. So-and-so, appearing on behalf of the private respondent, submits that the plaintiff's specific prayer made in the suit, more particularly the relief B and C, was in respect to as to whether the judgment and decree passed in title suit number 62/76, if relief sought for in the suit being more particularly relief B and C, would show that the judgment and decree passed in title suit number 62/76 have been thought to be nullified on the ground of being fraudulent, collusive, and void. The learned counsel, appearing on behalf of the private respondents, therefore submits that this was a substantive issue, and without the decision on this substantive issue, the trial court could not have proceeded with the disposal of the suit, and as such, the learned First Appellate Court was justified in framing the said issue. In addition to that, the learned counsel for the private respondents have also submitted that in the written statement, specific contentions, specific objection was taken as regards the as to whether the suit was barred by limitation. However, the learned trial court did not frame the said issue. In addition to that, the learned senior counsel for the private respondents had submitted that it is the bounden duty of the learned trial court ought to have taken into account Section 3 of the Limitation Act, which stipulates that even without a defense being set up, the courts are duty-bound to dismiss a suit filed, appeal preferred, or application made beyond the prescribed period of limitation as set out in the schedule to the Limitation Act. I've heard the learned counsels appearing on behalf of the parties and have given due anxious consideration to their respective submissions. This court have duly taken note of the plaint, wherein it was the specific case of the plaintiffs that the judgment and decree passed in title suit number 62 of 1976 by the Court of the Munsif number 2, Karimganj, was fraudulent, collusive, and as far as the fact of possession is concerned, and as such had sought for a declaration that the said judgment and decree dated 7/7/1977 of title suit number 62 of 1976 should not be binding upon the plaintiffs. It is also seen that the plaintiff's right to claim the relief for declaration of having landholder right over the suit property and for confirmation of possession also hinges upon the said declaration to be made in respect to the judgment and decree dated 7/7/1977 in past entitled suit number 62/1976. Under such circumstances, the learned trial court ought to have framed that issue, which hinges on the, which has a material bearing on the outcome of the suit. Having not done so, the learned First Appellate Court have framed that additional issue. This court also finds it very relevant to take note of that in paragraph number 3 of the written statement, it has been specifically mentioned that the suit is barred by limitation. Inasmuch as the decree in title suit number 62 of 1976 was passed on 7/7/1977 and the suit was filed in the year 2005. It is seen that the learned trial court not only framed this issue, neither framed this issue nor discussed anything on the question of limitation. Under such circumstances, the learned First Appellate Court had framed this additional issue as to whether the suit was barred by limitation. This court is also of the opinion that framing of these two additional issues may lead to adducing further evidence by the parties to the suit. And as such, it is the opinion of this court that the learned First Appellate Court, that is the court of the civil judge Karimganj, was justified in passing the order dated 33/2012, passed in title appeal number 39/2008, thereby remanding the suit back to the learned trial court for deciding afresh, including the issues, additional issues so framed. Under such circumstances, this court does not find any merit in the instant appeal, for which the instant appeal stands dismissed. First, taking into account that the parties are duly represented, they are asked to appear before the learned court of the, which court? Trial court is who? Court of the Munsif number 2, Karimganj, on 5th of August 2024. Special messenger deputy and all this thing. Return records here. Now, Mr. Just wait. Let us finish it. Here is a case that there is a judgment being passed. It was a stay being granted. Stay being granted because of the pendency of this. Isn't it? Now, that judgment which has been passed, 176/2005, is no longer there.
No longer there. Now,
It has now gone back to the trial.
Right.
So under such circumstances, if these suits are both together, you can very well file an application for consolidation.
yes, fine. Now, this is a fact clear by your losses, man. Our question is, my lord, after obtaining the judgment that is now remanded back by your lawsuits, 176/2005, while we are also plaintiffs with that, as 4, 5, and 6, there were 1, 2, and 3.
No, Mr. Rajbol Bhuya. Here the matter which is there, it was stayed for why? Because of the pendency of that second appeal.
Negative. Yes.
That second appeal is gone.
Gone.
Now, once it is gone, there is no judgment passed in title suit number 176/2005. It has now gone back to trial.
Trial.
Now, if you have a case out here, this case, this order has become now null and useless, which you are challenging. So now you can very well file an application for consolidation because there is no judgment. It may be a case under section 10 for staying it. That is another aspect of the matter. That is another aspect. But this order no longer survives.
Another fact is there, my lord. I beg to draw your lordship attention to page 2. In the same subject matter, they have obtained another judgment behind our backs. We
I'm
are
not
all
going to
along
look
there.
into any other judgment behind your back. Whatever may be, there are opportunities there, and I'm always here sitting to help you out. Now I'm helping you out, saying that you submit that your petition has become nothing remains, so that you approach the court, isn't it? Heard Mr. M.H. Rajbor Bhuiya, the learned counsel, appearing on behalf of the petitioner.
Impine order is 84, my lord.
Who are these? Number 1 to 12,
1 to 12, the legal heirs of the appellants, my lord. This South,
those appellants.
is appellant in this South, my lord.
So these are there.
The legal heirs.
And Mr. T.R. Gogoi appearing on behalf of the different respondent 13, 14, and 15. Mr. Chakravarti, you are putting in your appearance? No. It will become infructuous only. Do you want to put in your appearance? Because that matter is there, na? So, Mr. S.K. Chakravarti appears. Should I put your name? No. No, I'll put Mr. S. Mr. S.K. Chakravarti appears on behalf of the respondent numbers 1 to 12. This application under 2 to 7 of the Constitution is filed challenging the order dated 31/5/2023, whereby the title suit number 290/2022 have been stayed in view of the pendency of SAO number 5/2016. At this stage, it is very relevant to take note of that today, by an order dated as the order to so and so, the SAO number 5/2016 has been dismissed. And thereby, the matter has been, thereby, directions have been issued to the court of the Munsif number 2, Karimganj, to adjudicate afresh the title suit number 176/2005 as per the directions so passed by the learned First Appellate Court in order to control. In Appellate Court dated 30/3/2012, passed in title appeal number 39/2008. Taking into account that the instant order, which have been impugned in the instant proceedings, have stayed the title suit number 290/2022 till the disposal of SAO number 5/2016. And the SAO number 5/2016 has been disposed of. The order dated 31/5/2023 therefore becomes infructuous. Under such circumstances, this court closes the instant petition. Mr. Roy, that I'm just finding out wherever there is a SAO, this somehow got out somewhere from nowhere.
Okay.
Otherwise, all SAOs I'm finishing because SAOs are like CRPIOs, unnecessary. I do order yes. I say now order special message. No, that is why I brought the SAO because these are small petty matters ones
50,
Yes.
My lord,
Why did I fix it today?
my lord, to see the order dated 18/6/2020.
Ah,
What has happened?
what happened? What are you challenging?
My lord, I'm challenging at page 55, my lord.
Oh,
My
that
PW
one.
was closed.
Written statement, defendant witness. Uh, 10/7/2008. Chalo. Heard Mr. I. Iqbal, Iqbal, the learned counsel appearing on behalf of the petitioner. First, we should notice returnable on 5th of August 2024. Steps be taken by way of registered as well as usual. In addition to that, the petitioner is directed to effect steps by way of dusty routed through the registry of this court and file an affidavit of service on or before the next stage. Is an application by which the instant application, the petitioners have challenged the order dated 9/5/2024, 24, whereby the opportunity to file the defendant witness have been taken away, and whereby by the defendants, the petitioner who is the defendant in the suit, have been precluded from filing the written statement, defendant witness. Full stop. It is submitted by Mr. A. Iqbal, the learned counsel appearing on behalf of the petitioner, that the defendant is a 90-year-old person, and on account of that, on account of various ailments, age-old ailments, he could not submit. He, however, submits that on as and when this court fixes a date, the defendant evidence can very well be submitted. Taking into account that the next date is fixed before the learned trial court on 10/7/2023, this court stays the further proceedings of title suit number 88/2011. Full stop. This court, however, this court, however, directs the defendant herein to submit his evidence on affidavit on 10/7/2023 before the learned trial court, and the acceptance of the said evidence would be further considered would be subject to such orders that may be passed by this court.
Deeply.
But that will be, if I'm appearing, if I'm there, cost of 50,000, take it. Ask your client also to get ready with that 50,000. And the 50,000 will go to Namasana. We are now having it in the charitable institutions.
I have to apply for loan, madam.
Huh?
I have to apply for loan, madam.
Fantastic. Now we have fixed on 5th of August. You guys nowadays get your loan very easily. Very easy. No
Deeply
problem.
august.
by permission.
Yes, what is this? Very challenging.
Defendant petitioner, my lord, who died in the meantime.
Which order?
In case order is, my lord, section of the prayer 29.
What is the order, Mr. Shalia? The challenging 8/5/2023. What is that?
Page 31, my lord.
Petition.
Order is with 8/5.
For cross-examination.
Individual arrangement, dependent,
Individual-
time for cross-examination of PW1, DW1, perusal of the case record. Already 3 adjournments are given, and hence considering the absence of the reason of town shown in the prayer seeking adjournment, evidence of the adjournment will not be appreciated and expunged. Against that, may not be case.
How is it possible? You are the person who sought for time.
That the plaintiff sought for time, not time. That earlier petition is there, my lord.
Now, who is the defendant?
Here I am dependent.
I-
No, no. Even no worry, just.
13.
1-6 has.
Huh? 216/2013. Okay. Then
Where is it? That I have read.
C. Goswami. Who was C. Goswami? You are C. Goswami. You appeared earlier.
That is in same part.
There are two cases, my lord.
Another CRP 213, my lord, on mistake, my 213 CRP. on-
Then absolutely no. Service Wakalatnama has been filed on behalf of respondent number 1, 2, and 3 placed on record. Now record comes out. Who has filed? Yes, Mr. N. Chakraborty and C. Goswami.
Goswami is there.
Then why you are saying that you have not filed? You are not there?
I am.
Oh, forget about that. You take the other file, extra copy, not necessary. Yes, Mr. You are the defendant. Who is the defendant? You.
Right.
You have taken 3 adjournments, and as such, it has been expunged. What is the matter about?
Title suit is regarding
Suit for recovery of 73 lakhs. Isn't it?
yes, correct.
So what is wrong? What is wrong? Except mercy, there is anything else?
Nothing else, but mercy is, God mercy is there, because person has died. In
Huh?
the person has died in the meantime.
Who?
That person who has to be prosecuted, DW1,
He died.
he died, defendant number 1.
When?
For that, my lord, I have filed this application for imprisonment,
You have filed?
my lord.
Where?
I is here.
IA is in Igba. No, IA.
Eight, my-
When did he die? 30th September 23.
Yes.
This
30th
this was
September
passed on 8/5. Then you did not, there were no medical documents submitted. Chalo. And on the last occasion, it was also said last. 6/8/5/2023 for cross-examination of the DW's last. Cross-examination of the DW for cross-examination of DW1. 1, 2, 3, 4. Can't help it. To dismiss it. I hope- This is an application, heard Mr. D.P. Solia, the learned senior counsel assisted by on behalf of the respondent. An application filed under Article 2 to 7 of the Constitution challenging the order dated 8/5/2023, whereby the learned trial court had rejected the evidence of the DW, had rejected the affidavit, evidence on affidavit filed by the DW1 in view of the fact that on 3 occasions earlier, the DW1 did not present himself for cross-examination. This court have duly taken note of that on 7/1/2023, the DW1 had submitted his evidence on affidavit. Thereupon, evidence on affidavit, that too, after imposition of cost. And the learned trial court fixed 6/2/2023 for cross-examination of the DW1. On 6/2/2023, 10/3/2023, 27/3/2023, the defendant number one, the DW1 did not appear to face the cross-examination. Under such circumstances, on 27/3/2023, the cross-examination of the DW, the learned trial court fixed 8/5/2023 for cross-examination of the DW as a last chance. However, on 8/5/2023, the DW again did not appear, for which the impugned order was passed. This court, taking into account the provisions of Order 17, Rule 1, is of the opinion that the impugned order does not require any interference. Accordingly, this court dismisses the instant petition. The stay order dated, the order dated 17/7/2023 passed in the instant proceeding stands vacated, and the parties are directed to appear before the learned trial court on 5th of August 2024 for further proceedings. So yeah, I did not give what will happen? They have to substitute. And you now get the fine to again submit a written statement. Once you submit, then you obviously will get it. Nothing much. Yes, Mr. Sattar. The long order have passed. Why?
In view of your lordship's order dated 22/5/2024, my lord.
What is that order? Why did I pass such a long order? Service is deemed to be completed against the SPA and no. Oh, that one.
Yes, my lord.
Taking into account that this court finds it relevant to call for the records. So records is in sir.
Whether the summon was served upon Anil or
As to whether because it is a company.
company. And my lord, one thing your lordship has already pointed out that while filing the claim, the name of Anil Kumar was already there. Anil Agarwal was already there, my lord.
Now, whatever may be, you have to give an opportunity to rectify. If my only problem with that order was you did not give any opportunity to them. Yes, once you have found that yes, Anil Agarwal has no business out there, then you should have asked the company to participate. That is the order which ought to have been passed. Because otherwise, you can't. That is why you are here now. Let's see. Now you are not the director.
I am the director, my,
Where is your certificate of area?
my lord, that page number 40 and 41 of my. This is the company master data, my lord, page number 40. And at the second page, your lordship will be pleased to see that my number is 00402373, Anil Agarwal from 5/4/2007. Second in succession. And my lord, to that effect, the board of directors have also given certificate also, that is at the last page.
Yeah.
of Page number 47, my lord, regarding the recognition that I am the director, that is also there. At page number 49, my lord.
Now, this is not a document which was placed before the trial court. Annexure 7?
Annexure 7 was not placed. Not placed. Only that master, page number 40 and 41 was placed. That is the company master data.
Mr. Sharma, you want to take these root kings. Your basic idea of ejecting the root kings, the company. So if they duly acknowledge by this, and it appears in the master data, how does it make any difference? Anyways, now what is your thing is a landlord-tenant suit. If we interfere with otherwise and say that, okay, Anil Agarwal is not there, then the only thing is that you have to give them file to written statement and the suit goes back again to that stage where they are going to take up the same thing. Because the receipt is also by Anil Agarwal. And you have put it also in your plaint. No, if it is served to the company, wherein the name of Anil Agarwal is given, you categorically say represented by Anil Agarwal. No, no, Mr. Sharma, whatever may be, there is one judgment, just for example, in respect of a power of attorney also, a person may not have that power of attorney to exert, but subsequently it can be ratified. And this is a ratification. Now, if I have to, the question, Mr. Sharma, the question of not interfering with this order does not arise. But the interference, if I do it, the entire thing, you will be, I have to give an opportunity to them to file the affidavit, the written statement, which may alone again go to the stage of evidence.
In this appearance.
Then also, if it is said that Anil Agarwal, because you have not amended your plaint, you categorically say that represented by Anil Agarwal. So unless you don't do it, how can we say so? No. Who is to file pleadings? On behalf of the company on the order 29 rule 1? He can be the principal officer. He can also do it. And that ratification can be done subsequently also. There is no quarrel with that proposition. Do ratify the same and including the works done by him in the courts of Guwahati for and on behalf of the company. There must be a master data of 5.4. Where is that?
My lord, page number 44.
Page 40 is not that. This is the later on. No, he has said about this thing. 5417 is there. That one.
My
His
lord,
name appears out there.
yes,
You kindly see page 41.
first is my lord, 1/8/1997, that is regarding Manoj Kumar Sharma. Second is 5/4/17, Anil Agarwal. Third and fourth. Page number 41.
So they have the signatories. These are director signatory. These are there. Surrender DIN. So there is no surrender of the DIN as on that date. This is the AGM. This is of 22, but there is no surrender of the DIN. Huh? So go and
When the occasion has
go
arisen,
and
I have
catch hold of
taken
the
it.
MCS.
Yes, my lord, I have certified. It's written. No.
Show me that. I'm coming in 5 minutes. Huh? It's not there in the annual returns.
Third.
The name does not feature in the annual returns. Why? And where is the registered office of this company? Where is the registered office of this company?
Calcutta, my.
Huh?
Kolkata.
Then there is no service upon the respondent, on the defendant. Huh? How are you serving it at the area? If we see order 29 rule 2,
In the plaint, only one address is mentioned by them.
are you serving?
The plaint, my lord, only one address is mentioned.
That is why I'm saying the entire suit should fail. We see order 29 rule 2. What does it say? At its registered office, and if there is no registered office, then at the place where the corporation carries on business. That you are adding. No. Yes, you may confer a jurisdiction on the basis that they have a place of business out here. There's no quarrel with that in view of section 20. But here it says that by leaving or sending it by registered post to the corporation at its registered office, and if there is no registered office, then at the place where the corporation carries on the business. Then if a service is being meted out here in Guwahati, and that too represented by so-and-so, who, as per you, on basis of these documents, is not the director, then there is no service upon the respondent, defendant. And if it is no service upon the defendant, the suit has been wrongly filed.
Filing may be there, but wrongly continuing.
No, wrongly filed. It
Wrongly
can't be
filed,
it
yes.
can't be filed against the corporation if it's a company. If there is no registered office, now for that, in view of the explanation to section 20, you may confer a jurisdiction upon that court, but not territorial jurisdiction. But how can you affect service in view of the proposal of order 29 rule 2? So we hold that the service is completely bad, because I would have understood if you have put the registered office here and thereupon said that represented by so and so director. You yourself admit that Anil Agarwal is the director, you get his service, he files his written statement, issues have been framed, now you raise up issue out here to that effect. That is one thing. Or the second is, You accept that in view of this ratification being done on the basis of Annexure 7, you would not like to further raise this issue any further and thereby continue with the suit, and it will be deemed that this is a ratification being done by the company. Matter ends there. I think that is the best way out. No, matter has to end. I have to set aside this order. Otherwise, they don't have a defense. And because final hearing, what will happen tomorrow? At the final hearing, if it is found that, look here, he doesn't have the authority, how do you take care without an amendment to your claim? The service is not in consonance with Order 29 Rule 2. So the only way is accepting that Annexure 7. And you proceed with that. Because otherwise it will have the entire suit will go yours. And I'm not worried on other things. Your limitation will go. Appreciate that. Your limitation will go. We are in 2024. Yes. No, otherwise I would have understood. No, I would have understood, Mr. Sharma, if your suit categorically says so and so, having its registered office, so and so, it is done. But you say that represented by so and thereby you make it a representation by Anil Agarwal, that company, by your admission on the part of your plaintiff. Now, can you now say, no, Anil Agarwal is nobody. When we filed the suit, we made a mistake. We did not look into the records and filed it. He was a director, because another thing is, there is another aspect of the matter. This is a case for recovery.
Eviction and recovery of area rent.
So it's the recovery of rent and recovery of area rent will go, but for ejectment may remain. You can file your ejectment at any point of time. I think you should. Now they ratify it. I'll mention it on the basis of this. You further would not like to question that, and thereby the suit, and they cannot now resile later on that no, we did not do it. This is a document which has been given to this court, and on the basis now they have to accept what Anil Agarwal has said. They can't now resile back. That I think would be. So therefore, because that document, otherwise there are a lot of difficulties which you are going to face. And you want to evict them. Again, going back to the stage of pleadings, or even for the purpose that the framing of the suit may not be in the proper manner, then how do you take care of it? It may not be, it will be winning a battle and at last we will losing the war. I think for your progress, I think you need to accept that, which is that document, and we take it that this is a document which has been given to this court. And as such, it is a rectification by the company as regards the filing of it. And as such, the company now will be bound. And therefore, you say that you are not pressing that issue, for which I set aside that order. I think that is a better way for you to progress. Which was not there before the trial court. I think that is a better way. Yes. Then your suit will progress, no? I think yes. This is an application filed under Article 227 of the Constitution, challenging the order dated 30/9/2023, passed by the learned Court of the Civil Judge Senior Division Number 3, Kamrup Metro at Guwahati, whereby the written statement filed by the petitioner, who is the defendant in the suit, was struck off on the ground that the person who filed the written statement was not authorized by the defendant company, by the petitioner company, the defendant in the suit. Full stop. This court have duly taken note of that in the plaint, the defendant have been described as, inverted comma, Road Kings Private Limited, comma, full stop, a private limited company, full stop, represented by its director Sri Anil Agarwal, having its office at Malik Compound, Railway Gate number 5, 80 Road, Guwahati 781001, District Des Kamrup, M, Assam, page 40, 12 Full stop. In pursuance to the summons being served, the said Anil Agarwal filed his written statement on behalf of the defendant company. Full stop. The suit thereupon progressed by framing of issues and was fixed for the purpose of filing of the evidence. Filing of evidence.
Yes, madam.
When an application was filed that the said Anil Agarwal had no authority, was not the director of the defendant company, and had also no authority to file the written statement, and accordingly sought for striking out the defense of the defendant. On the basis of the said application, the impugn order was passed whereby the defense of the defendant was struck off. It is against that the instant petition has been filed. This court duly takes note of Annexure 7 to the instant petition. The contents of Annexure 7 is reproduced herein below. To whom it may concern, certified here. From the perusal of the above quoted, page 49 of the, from the perusal of the above quoted resolution and certification done by the directors of the defendant, it appears that the defendant company have duly accepted that Anil Agarwal is the director of the defendant company, and since 2017, his name has been appearing in the master data dated 5/4/2017. In addition to that, the defendant company had also acknowledged and ratified all works done by Sri Anil Agarwal for and on behalf of the defendant company at Guwahati, and including the works done by him in the courts at Guwahati for and on behalf of the defendant company. Taking into account the enclosing of the said document before this court accepts that Sri Anil Agarwal was duly authorized by the defendant company to file the written statement. And as such, any consequence which would befall upon the defendant company in view of the written statement filed by Sri Anil Agarwal also accepted by the defendant company. Accordingly, this court interferes with the order dated 30/9/2023, whereby the written statement filed by the defendant company was struck off. I could see here.
It was fixed for PWs and.
No, yeah. It is here. could see not steps before plenty bearing. You see, in view of the order of directions, so as per both.
My lord, that
No, no, files. At the stage of steps before preemptory hearing. So here to there was fixed for evidence to be assigned. Taking into account the above, this court therefore vacates the order dated 22/5/2024, whereby the further proceedings of title suit number 441 of the 2018 was stayed. Taking into account that both the parties are duly represented, the parties are directed to appear before the learned trial court on 30th of July 2024. The registry shall forthwith return the records before the learned trial court to the court of the Civil Judge number 3 Kamrup Metro at Guwahati, so that the said records are received by the said court or before the date so fixed by this court. In that regard, the registry may also employ the services of a special messenger. Because otherwise you will have problems. Huh? Everybody. One thing, Mr. Sharma, I realized while practicing in the civil court, it is always to lose small battles for the further progress of the suit. When it has major implication, it is otherwise. Huh? Yes, cross, I think, would have been the better option. And if you have raised that at that point of time in the cross and then said that you have not been authorized, and then on the basis of Order 29, Rule 1, you could have finished it.
Item 8.
Yes, Mr. Sheikh.
Concurrent judgment, madam.
You have a case?
My lord, my case is this, my lord. The learned appellate court in 2 points, my lord. That suit is barred by.
Mr. Sheikh, I'm telling you, if you don't have a case, don't argue, don't get a dismissal just before the vacation.
Court below held that the case is barred by res judicata. Number 1. And number 2, my lord, that necessary party.
These are the two grounds. Both the courts.
Both the courts.
A necessary party and
Necessary party and res judicata.
okay. Now, therefore,
My plea before your lordship is this.
let us see
that
what is
res
who is the
judicata-
necessary party who have not been made. There were 4 points of what was the issues framed. Whether the suit is bad for necessary
Case
parties,
34.
whether the plaintiff has right, title and interest, whether the plaintiff has possession over the suit land.
So, my lord, here another point is this, on res judicata, no issue was framed. Your lordship got it in 34, page 34. No issue was framed on res judicata, but my case is dismissed on the point of res judicata.
No, that can be very well taken to when everybody knew about that. That the res
Now,
judicata would be always there.
actually,
There is no question of giving evidence. Res judicata will be only on seeing as to
that
whether
is-
the said
that is on
judgment has
record. Now, my lord, what happened? A suit was filed in respect of another land
Hmm.
and another party, in between another party. So, my lord, suit is different, its subject matter is different, party is different. However, the question of res judicata will come.
Have you brought in those judgments earlier? Earlier judgments
Earlier
on the
judgment,
basis of which res judicata was applied?
my lord, the judgment of Munship 30, my lord, page 30.
Huh?
From 30 onwards, my lord.
30
Yes,
is the earlier suit.
yes, my lord, earlier. Your lordship will see at page 35.
No, this the trial court suit?
Yes, my trial court.
No. I'm not saying that. I'm saying, did you bring on record the earlier suit, the judgment, where it is said that
That is reflected in the judgment itself. The judgment itself,
Ah.
your lordship will turn to page 35. Page 35, first paragraph, my lord, in the middle. On the other hand, defendants in their WS has specifically pleaded that the suit is hit by section 10 of the CPC. I have perused exhibit 8, that is the certified copy of judgment passed by the Honorable Guwahati High Court in second appeal 4/1994. After perusal of exhibit 8, it appears that the subject matter TS number 172 of 83 included the land covered by that number 710 of Khutiar number 101. That is the subject matter of this suit. From the schedule of the plan, it is well as per exhibit 8, it appears to me that the subject matter of this suit is also one of the subject matter of the TS number 172 of 83, as well as second appeal 4/98, whereby the Honorable Guwahati High Court has already affirmed the judgment of title appeal. Thus, it apparent that the issue relating to the land covered by tag number 719, Khutiar number 101 has already been decided by the exhibit 8, section 11 CBC speak about the doctrine of res judicata and fallacy.
Say regarding non-gender, it is okay. I think you may have a case, but that would not by itself be a substantial question of law. Because on the issue number 5, as well as the issue of maintainability on the res judicata, that both the trial courts and the you have to show me that the trial court category, the trial court and the first appellate court categorically comes to an opinion that the land is the same.
My lord, your lordship, be pleased to see my shoot land, schedule B. At page 18. Woodland is schedule B land, page 18. Woodland is schedule B
because-
land, which is part of schedule A.
And there is no boundary.
My lord.
Huh?
Boundary is there, my lord.
Where?
Here that schedule A, my lord.
Schedule A is 11 bigas.
My lord.
How can 11 bigas and 3 bigas will have any boundary?
My lord, yes, boundary is there. Your lordship will please to see 18, page 18.
That is what I'm looking into.
Yes, my lord, schedule A.
Oh, there.
village
Page
road.
19, boundaries are there.
Yes, my lord, page 19.
Then
Boundary is there, page 19. B schedule boundary is there.
Then?
So, boundary of B schedule land is also there, A schedule also there. Now your lordship would be pleased to see Jodhari Khotiar number 261. A schedule land, Jodhari Khotiar number 261. Khotiar number 101, tag number 710. Now your lordship would be pleased to turn to PS number, that is page 35. That is their case, my lord, written statement. PS number 172 included the land covered by tag number 710. 710 is all right, my lord. Included by tag number. Khotiar number 101. Here, our Khotiar number, Jodhari Khotiar 261.
in Khotian number 101.
101.
Then,
Jodhari Khotiar is 261.
but the other is Khotian number 101 is also there along with it.
Maybe, but it is a land of Jodhari Khotiar.
These are question of facts. The trial court and the first appellate court has already held it against you.
Your lordship, another thing your lordship will consider, party must be same.
Why?
Party must be same. We are not party in the case. The title should, we are not party. It is a case against one Hassan Ali. How that res judicata will come to me? Case was decided against Hassan Ali. That is my
Who is Hassan
specific
Ali?
case.
And who are
Hassan
you?
Ali, I am not Hassan Ali.
You are third party.
Third party, my lord, I am outside this.
Huh?
I am not covered by this shoot, my lord.
Therefore, I was saying, where is the judgment? Bring down record that judgment and plaint of the earlier suit. Because the judgment is exhibited. It has been exhibited, as I could see in page 35, exhibit 8.
Yes. That is on record, my lord.
Bring it. And only framing. I don't frame substantial question of law like this.
So, my lord, my specific case is this, I am not party in that shoot.
So you are
83 shoot, I
party,
was
but
not-
no,
I was not in party.
you may have been a party, you may not have been a party, but are you claiming rights on that?
My lord, your lordship will see page 15. Page 15, my lord.
Hmm.
Para 6.
What do you say?
That Lokman Ali and Abdur Rahman, they were the son of original Jodhar, my lord, who inherited the property of their father. It is my plaint, my lord. Yaqub Ali, file PS number 172 of 83 against legal heirs of Hassan Ali Haji, who was tenant of Yaqub Ali over a plot of land measuring 2 biga 2 kata 11 lesser, covered by Jodhari Khotiar number 261 so and so. But TS number 172/83 was dismissed by Munship number 2 Dhubri on 25/5/95 due to which title having being 25 of 95 was filed against judgment and order dated TS number 172 of 83, wherein judgment and order of the TS number 172/83 was set aside on 4/12/97. So essay being filed 4/98 was filed in the Honorable Guwahati High Court against TA number
Where is your statement that you have nothing to do with those people?
Hello.
Where is your statement that you have nothing to do with those people?
That I have said that Hassan Ali Haji is not connected with me.
Where?
My lord.
Where is the statement in your plaint? This is the matter after summer vacations.
Allah.
By that, who's the Mr. MA6 shall file an additional affidavit bringing on record Exhibit 8. Exhibit 8.
Exhibit 8.
Exhibit 8 is the document, no?
Written statement. my lord.
Exhibit 8. That's the judgment of this court.
Exhibit 8.
8. 8 for
My lord,
Eight.
Page 35, my lord.
page 35. Exhibit 8.
8. Yes. Oblige, your worship.
Defendant's appearance when the court of courts below. Plaintiff suit was
You have a case or not?
lordship apparently. Yes, I have a case. Because
Yes.
that shell deed, which they say they claim that it was a forged one. They are to lead the evidence that it was a fraudulent one. So they submitted only the certified copy of those shell deed 5 and 6, which we have also exhibited as A and B. At page 11. Whether the burden of proof lies upon the plaintiffs to establish the alleged fraud in the execution of the shell deed exhibit A and B, research shell deed under section 101 of Evidence Act, and in absence of discharge of the said burden of proof, the impugned judgments are not sustainable in law.
What is Exhibit A and B?
Exhibit A and B which they claim that it was a fraudulent one.
2/4/2014 and 15/7/2015.
Lordship.
Burden is yours.
No,
You are the plaintiff.
no, I were the defendants.
So, it is the burden of the plaintiff.
Plaintiff, they did not prove it.
And is that they found that it is your burden? Let's see. Trial court, how does it say?
It is only on oral statement that it was, we misled the lady, plaintiff number 4, that it will be a blank document and we took signatures and thereafter we executed the shell deed.
So that's the burden.
That is our,
So that is the discharge that has been done.
that has been cross-examined. No. In that case, she admitted that she signed it. It was they, in that case, they should have brought that circular or is it called registration officer's man to prove that yes, it was not, there was no signature of the volume book or otherwise fingerprints are not there. Those things they should have done it. That somebody else represented her.
Let us
So-
see how the trial court deal with that.
Trial court only on the judgment. Judgment at 26 to 60. By issue number 2 and 3, whether the plaintiff number 4 executed shell deed so and so, and whether shell deed so and so is a fraudulent. These two issues
Where is it? Two and
at
three?
page 34.
Not discuss it like issue wise.
45, whether the plaintiff has four executed sale deed in favor of so and so. The existence of sale deed 798 dated 2/4/2014 and sale deed number 1763 so and so shows that the same was executed irrespective of the fact that whether they were executed legally or not by the plaintiff number 4. But the plaintiff specifically pleaded that the defendant number 1 and 2, taking advantage of the plaintiff number 4, who is an old aged lady, illiterate and simple rustic village lady, will promise to provide a bank loan to her to the signatures and some blank papers, Indian non-judicial papers, stamp papers, and some printed forms. And then, without knowledge of all the plaintiff, they converted those signed papers into sale deeds in their names. From the evidence of the plaintiff, it is evident that the predecessor of so and so. It is a fact that it was in their name. Exhibit 1 and 2 was the original.
But the property belonged to one Tita Mohan Roy.
Yes,
And
it was inherited by all
who executed the deed of sale?
plaintiff number 4, mother.
How is it possible?
She cannot enter sale, she cannot do, but
Yeah.
at least her share can be, she can transfer it. At least her share, she can transfer it. But it was registered, it was mutated in her name alone in the 1990 itself. They have not explained why they did not file their mutation application before the court, before the circle officer, to include their name.
How does the learned trial court come to the area that plaintiff number 4 did not execute?
It is only that thing. It is, though it is admitted by herself in her admission, in her evidence that she signed it, whether it was a sale deed or bank document, that is a different issue. But she has admitted her signature. So therefore, findings given by both landlord trial court as well as appellate court is not sound one.
Let's see how does the trial court, first appellate court deal with it?
First appellate court in the same, almost a replica.
Replica?
Replica. 61 to 81. Issue number 3 and 4, 71.
Are these SMS people? Parties,
They signed it, they're Assamese people.
SMS.
Assamese.
So
Just
how they are bringing the proportionary aspect? Heard Mr. B.K. Bhagavati, the legal counsel appearing on behalf of the appellant. The instant appeal is admitted by formulating the following question of whether the learned courts below were justified citing the issue number 2 and 3 in favor of the plaintiffs merely without taking into consideration Section 44 of the Transfer of Property Act 1882. Whether the learned courts below were justified in decreeing the suit in favor of the plaintiff in accordance with the provisions of now, whether the learned courts below were justified in decreeing the suit in favor of the plaintiffs, thereby declaring Exhibit A and B as fraudulent.
Exhibit 4 and 5 oblique A and B.
A and B oblique 4 and 5 as fraudulent. What are the deeds of sale? Holding by the deed of sale bearing sale deed number 798 dated 2/4/2014 and 1763 dated 15/7/2014 as fraudulent in terms with Section 101 of the Indian Evidence Act 1872. All for the records, steps within 3 days, registered as well as usual. What is this IA for?
I for stay.
Why? It's an execution.
No.
Well, your what was the suit for? Declaration and recovery of possession.
In fact, that is a doubt, there is a doubt whether we follow it or not.
No, there is no recovery or it is not an executable decree. Is it that day? Let's see. What is the decree passed? Well, it's executed so and so, and a dependency. Who are in possession?
We claim that we are in possession.
Plaintiffs have right title and interest in possession. So there is a declaration that they are in possession.
That is the doubt, there is a doubt. I have also doubt that is whether we are in.
We issue notice
All right.
for the time being. No? Because why I'm issuing notice? Because once it is being strike down,
Yes,
with this decree, they may
yes.
issuance of a precept.
Receive.
There might be further complications. We issue notice now. I cannot issue notice returnable. I cannot. Heard Mr. B.K. Bhagavati, the learned counsel appearing on behalf of the applicants, was to issue notice returnable by 28th of August 2024. Steps be taken upon the respondents by opposite parties by registered and usual. Further, the question of staying the judgment and decree shall be considered on the next returnable date. I say returnable now. Issue notice returnable. Same date kore dibo. Records. As with you, Mandy. Yes,
Lordship, accommodate me for today, Lordship. I have heard this matter.
what do I
Lordship,
read?
Not satisfied with the substantial questions of law, Lordship. I have given a sheet of substantial questions of law, Lordship,
Ah.
regarding partition suit, Lordship.
Then,
They are the defendants and plaintiff prayed for partition of her share, Lordship. She is the
you have a
daughter.
case?
Lordship, trial court dismissed their suit, first appellate court reversed. On the ground that we have already given her share over from the scheduled C. In spite of that, she again claimed lands from other property, Lordship. Trial court held that once she has admitted that she had received some land, 1 katha 10 lesa, and she already sold out that land, Lordship.
Then,
Then, Lordship, first appellate court says, Lordship, in other lands, there are some shares, so she is entitled for the share, Lordship.
so your suit was dismissed.
I am defendant, her suit, Lordship.
What was the suit for?
Property of her share, Lordship.
I'm the daughter of son of the family tree.
My case is that, Lordship, the originally suit lands are belong to one Jadu Bora, and he has two sons, Lordship. So other sharers are also there, Lordship, but she has misstated the court with saying that our father is the
Who is the
original.
plaintiff? Who? Daughter.
Daughter of friend of Bora.
And who am you are fighting amongst whom?
brother.
And my brothers and sisters and
Who is the mother?
Mother, appellant number 2, Lordship.
now is the mental.
Huh?
By the
Mentally sick. The permission was taken,
now she is mental.
but have you taken any permission? How are you appearing then?
Lordship, she's put her signature on her own, Lordship.
Huh?
Her on her own, Lordship. There is no.
Your
no that
mother's name is Bogimai Bora.
No, Lordship. Punno Prabha Bora.
Huh?
Punno Prabha Bora.
Punna Prabha Bora.
I for Babul Bora.
So the daughter is asking for of the property of Surendra Bora.
Other two daughters are supporting her. Other two daughters are supporting her.
Who?
Bora and Dipamani Bora. Dipamani supporting her. And
Dipamani too died unmarried.
Dipamani Bora.
They are supporting her. So 3 versus 2.
One plus one lady.
Mentally sick. Now from sick we are now coming to stable.
They have admitted. Also they have admitted.
Huh?
Also they have admitted. Admitted in their WS. Backup number 11. Cross. This is the property of Surendra Bora. On and visa.
And what is their defense? What is their defense?
Defense. What was divided. Babul Bora. Surendra Bora has taken less. Babul Bora has taken more. Backup number 15.
How does Babul Bora come into the scene again?
Our uncle.
Backup number 15.
So they say that they are not the owners.
They're the owners. Bogari Bora and Surendra Bora file a joint WS.
Who?
Bora, Bogimai Bora, and Bora. And the Dipamani Bora has filed a joint WS. WS in paragraph number 11, all have admitted our claim. This is a property of Surendra Bora. Paragraph number 11. In paragraph 15, they said that because has relinquished some portion of land, but no any relinquishment deed was submitted by them.
So then trial court dismiss. Why did the trial court dismiss it?
That was because Dalga has said that the plaintiff could not beneficiate her share and we have not beneficiate her share and come with unclean hands. Because at the lifetime of his father, Swana Bharat, he has given the land to the plaintiff, a portion of that. Lifetime, a portion of that was sold by the plaintiff. Portion of the father.
So that was your share. No, no, did the trial court hold it? That you had already taken your share, then where is the partition?
But total share is 1 bigger 3/4 6.5 lesser.
Okay, 2 o'clock, or we have it after vacation?
Cross, uh,
As per you, this is a case for dismissal? Or streaming of substantial kuch nahi? The matter be listed immediately after vacations. Like 2024. 24.
Apply.
As per office code dated 20/12/16, service in respect of the refer 1 and 4 and for formal definition of 1, 9, 19 and 20.
Which 1 and 4? Who is 1 and 4?
They are the 20 with the pins. They are the 20 plus.
One and 4. 1 and 4 are all plaintiffs.
21
You
and
are
4.
paying for 2. Mister? 2, 3, 5 and 6. You are paying for 2, 3, 5 and 6. So why you are not paying for other 2? Who expired? And 4? N. Ahmed. Mr. N. Ahmed submits that he represents the respondent number 2, 3, 5 and 6. First up, it is seen that respondent number 1 and 4 are also related to the respondent number 2, 3, 5 and 6. Mr. N. Ahmed submits that to his information, respondent number 1 had expired. First up. Taking into account the above, list this matter again on 29th of July 2024, on which date Mr. N. Ahmed shall get details as to when the respondent number 1 had expired and as to whether the respondent number 1 is survived by any legal representatives and the names of such legal representatives. And further to that, as to whether he would be also appearing on behalf of the respondent number 4.
In this case, the appellant has expired on 7th of April 2024.
Who is respondent number 1A, 1B?
One is the total service has not been completed.
Who? It is IA. IA is for what? Then? Then? 1 day after.
One.
Then appeal has been filed against whom? No, this I is against on the death of Prafulla Kumar Sarkar. No, this IA for condonation is also. Huh? No. Application under for filing the connected application. What application?
Substitution application.
Substitution application, do you need application for under section 5?
But the suit abated due to the death of the respondent. In fact, my lord, it was.
How can it abate? Has the appeal been admitted?
No, my-
So under such circumstances, at the time when you filed the appeal, Prafulla Kumar Sarkar had already expired.
Yeah, that was not, because we came to know only after when notice were issued in the second appeal, my lord. Only that point. of time.
Understood. So it was filed against the dead person.
Yes, my.
So you need to file an order 1 rule 10. Read with section 146 to implead them. Because it is not a case of substitution. Substitution happens when the matter is pending. This person died 1 day after the decree. So under such circumstances, thereafter, during this period, you have to file against only those persons. So you need to seek a leave under 146. This is how you do it.
In fact, my lord, the appellant has also died, my lord, in the meantime.
Fantastic. Then forget about the matter. When he died?
7th of April 2024. And we have informed they are not coming up. They said that they will be engaging some other counsel.
See, your petition is totally misconceived. And when did you file the appeal? After 9 years. 9 years. 2011. You filed it in 2019 or 2017. So the condonation delay is yet to be taken into account. An applicant has died.
Applicant has died.
Take on the action condonation application. Order. This is completely misconceived application. You see that there is a judgment, which is a very beautiful judgment on section 146. Have a look at it. It's a constitution bench judgment. How you act. Very old judgment, 54, 55. It's a very beautiful judgment. Now await service report. What is this? 80 days. Huh? Why is it 80 days? If the judgment was passed in 2011, Sir Mukherjee, what is this type of application? Condonation application is for 80 days? Appeal is filed on 19/8/2011. And there is a delay of 81 days. Not much. Thereafter, it is not yet been registered. It was registered subsequently. Delay has been condoned. No.
No, I am not.
So how the appeal had been registered then?
There was a time, my lord, along with the IA, the
Appeal was
Yes,
registered.
my lord.
Okay. দেখো কি কোনো, হ্যাঁ। But what you need to do is Prafulla Kumar Sarkar, I think you need to substitute, not substitute, you have to file an application in this case. For under order 1 rule 10 PTA, because there is no question of
Yes,
substitution.
yes.
Substitution, 90 days, all these things come.
It was came to know only after receipt of notice in the second appeal when notice were,
You have filed against the dead person.
yes.
The counsel appearing on behalf of the applicant submits that the applicant had expired on 7/4/2023,
24.
24, and he would therefore require some time for for taking appropriate steps. It's the matter on 22nd of July 2024.
Like,
খনত লিখিব দেই এইটো বাকী বোৰ নালাগে
Please, your lordship. Lordship, kindly adjourn the matter for the day. It's not feeling well.
Who is your senior?
Iman.
Is fighting elections?
Yes, lots of tension and.
Okay.
Lordship, after vacation,
Counsel appearing on behalf of the petitioner, applicant, seeks for an accommodation. Started again, that's 3rd week of August.
yes, lordship. Please, your lordship.
Service? You have not filed the affidavit of service?
Lordship, I have two submissions to make, Lordship. First of all, Lordship, as per the last judicial order, upon respondent number 1, usual process and dusty. We have taken the usual process, also the dusty. I have the receipt copy, Lordship, wherein from.
Yeah, have you filed the affidavit or not?
No, Lordship, it is there, but I would like to strike out the respondent number,
Whom?
respondent number 1.
For what this is?
Since it is for condonation of delay. 170 days,
Who, Mr. Kyle, you are paying for? No, you want to strike off one.
But subsequently, I have gotten order wherein in the suit, it was ex parte. He never appeared. And another limb of my petition, lordship, most probably, I have filed the revision petition in under wrong section, lordship. It has to be.
What order you are challenging?
Lordship, may find it.
Number 1 is right.
Huh?
Yes, 2015. I came.
Number 1? 1 died. And 2 is Labumia.
He is representing Labumia, lordship.
What is this case about?
Lordship, actually, in the title suit was of the year 2010, wherein compromise decree was passed in the year 2010 itself. Then title execution case was there in 2017, lordship, wherein an application by the defendant number 2, I mean Labumia, was an application was filed under order 21 rule 29. And the honorable learned court below has dismissed the execution case.
Which application? Under 21-29.
My limited prayer in this revision petition was that it should be stayed, because as per 29, the proceeding is.
Okay.
That is
So
what
if it is under order 21 rule 29, an appeal will lie against that, a revision will lie, or 227? 227, if it is there, where is the question of delay?
That is what, lordship, my submission is. It was filed in the year 2019. I have mistakenly, it was filed under 215.
Then let us do one thing. Miss I Das. Miss I Das, the learned counsel appearing on behalf of the petitioner, submits that inadvertently the instant proceedings have been filed under section 115 of the Code of Civil Procedure 1908. She submits that the proceedings ought to have been under the provisions of Article 227 of the Constitution. Under such circumstances, she submits that as there is no limitation in filing an application under Article 227 of the Constitution, she would not like to press the instant application for condonation of delay. Accordingly, the IAC number 3655/2019 is closed on withdrawal. Full stop. The registry shall re-register the civil revision petition as a proceedings under Article 227 of the Constitution. Accompanying revision petition under the Article 227 of the Constitution of India. And thereupon list the matter for motion immediately after the summer vacations. Full stop. The learned counsel appearing on behalf of the petitioner, applicant, shall also file a fresh post title before the registry within 15th of July 2024. Copy of the revision petition be served upon Miss Aida Das is further directed to serve a copy of the revision petition of S.C. Kyle, the counsel who represents the respondent number 2.
Deeply obliged.
In this case, my lord, I was directed to deposit 5,000, my lord.
Oh, did you?
56, already deposited.
Huh?
Amount has been deposited.
Where?
Before the registry, my lord.
Then
I dispose of 56 and there is a office note 24/6, my lord.
what does it say? Delay subject to payment of remand and according the learned client deposited, but no order was passed in IA to the subject and abatement. However, Ms. Case Albert is responding. That's for condonation.
Yes, my lord. Substitution of legal here, sole respondent expired. Thereafter, wife and daughter to impede. We file death, Miss IA, my lord.
Who died?
Sole respondent, my lord. My brother. So, my brother.
How did you not file the application within time?
Because my lord, earlier we filed, but because of some wrong information given who was conducting the case lower court below.
Huh? You were lucky enough. You got a very lenient judge. Isn't it? 1627 days delay. Brother.
Brother.
When her come to know and give them. Prior to that, my lord. Her husband already expired, my lord.
I have said it.
Record is fixed.
It says order was passed ex parte.
Contest.
I have filed objection. Please be allowed, yeah.
I didn't. 1627 days. And he gets out with only 5,000. Okay, we impose another 5,000 in the other two applications. Make it even.
But
Can't help it.
IA, my lord, main IA, that is 30 days delay. These two IAs are filed in the IA, miscase, my lord. It was filed in the year 2024, 14.
One is for condoning delay, it has been done. Now setting aside abatement.
Yes.
Okay, tell me why should
So
we set
19
aside abatement?
Miscase 1921, 2014.
Now, these 58 and 57.
Yes.
So why?
But, for setting aside abatement, my lord,
Ah,
that is, board did
you are not in touch
yes, my lord.
with anybody.
Now, my lord, I have stated everything here in paragraph 3. my lord.
Meena Deka Thakuria.
Already there was one IA also filed, miscase filed, my lord, in the lower court below. That cannot be divided. This order has been passed, my lord. Partition case, my lord.
Hello. The hawk aegi kon. 57 and 58. This court have duly taken note of that by an order dated 14/11/2022, this court had condoned the delay of 1627 days in filing the applications for setting aside the abatement and substitution of the legal heir of the sole respondent in miscase number 1921/14, bracketed the IAC number 56/14.
14, that is for
Oblique
the
2020. First. The instant application, pursuant thereto, this court had also directed the applicant to deposit a cost of 5,000, which was duly paid, deposited on 18/5/2023. Taking into account that this court had already condoned the delay and the right to sue survives against the legal representatives of the sole respondent, this court sets aside the abatement as regards the sole respondent and substitutes the legal representatives of the sole respondents whose names appear at paragraph number 2 of IAC number 58/2020 as respondent number 1, 1 and 1, 2 to the accompanying second appeal. Both the petitions therefore stands allowed. The counsel for the applicant appellant is directed to file a fresh memo of parties before the registry of this court within 7 days from today. The registry shall, on the basis thereof, make necessary correction in the cause title of the accompanying, what is that? Second appeal. Second appeal, and list the matter. There's a condonation of delay also.
Yes. 30 days.
Accompany in condonation of delay. Yeah, full stop. In the second appeal, shall file two fresh memo parties in both the second appeal as well as also in the application for
Yes, yes.
condonation of delay. And on the basis thereof, the registry shall make necessary correction in the application for condonation of delay as well as for also in the accompanying second appeal. And thereupon, and also update the same in the CIS. IA conjunction for condonation of delay.
1921.
Huh? Delay condone. No, this is a different one.
That is my in the
Ikon beleg. 1921 no, aru ase. What is that?
1921.
No, 1921 has been disposed of.
That it is wrongly, that is that place, that
Process,
56, my lord. 56 was
36 ne ki ekhon.
wrongly, that copy is also entered there. Actually, 1956 IA.
Okay. The registry shall thereupon list the matter for condonation of the, for orders for consideration of the condonation application. No, let us first issue notice in that. Your name should be shown, Mr. PP Das, the names of Mr. PP Das be shown in the cause list value.
Correct.
Post. Yes, Mr. H. Das. Find out which is the condonation application, then run away. Yes. Yes, madam.
Please, Your Lordship. Lordship, this court has directed to file the substitution.
Copy of the next of kin certificate of the legal representative of the respondent number 2 and 7 has been provided by the learned counsel on behalf of the respondent. Yeah. Then, have you filed an application?
We have filed the IA regarding the substitutional list of
You
the.
filed, it has not come.
No, Lordship.
When did you file?
21/5/2024, Lordship.
Ms. So-and-so appearing on behalf of the
IA was filed, Lordship.
applicant submits that application for that certain miscellaneous applications have been filed in the matter on 21/5/2000.
31/5.
31.
IA was filed. One is Lordship delay of condonation.
31/5.
Yes, Lordship. One is filed 21/5/2024. And
I
another.
filed certain applications for condonation of delays, setting aside abatement as well as for substitution of the legal representative. However, the same are not on record, list the matter immediately after application bringing on record.
Obliged, Lordship.
What is this?
My lord, lordship, last occasion directed to file an affidavit regarding the advocate that Mr. Ahab was in the, my lord, record or not, my lord. I could not file.
You filed an affidavit?
No, my lord. No, my lord.
Who has filed affidavit?
My lord.
I've asked you to make an inquiry.
Yes, my lord.
Who is this?
My lord, that was my lord. I have communicated, my lord. Information received, my lord, but I could not file affidavit because, my lord, the appeal was filed through power of attorney holder, and that attorney holder was died on, my lord, 21/10/23. So now we have required to Palatnama from the original appellant, my lord.
21?
21/10/23, my lord.
And then?
And,
as of now, you have no authority.
yes, my lord.
You have no authority.
No, my lord. Only that information got morning, my lord.
Appeal was filed.
Appeal was filed by the power of attorney holder, and that power of attorney holder died, my lord.
Mr. So-and-so appearing on behalf of the appellant applicant submits that the appeal was filed by through a power of attorney holder.
Lal Singh Jadhav, power of attorney holder.
However, the said power of attorney holder had expired on
21/10/2023.
21/10/2023. He therefore submits that some time may be granted to him for filing the Wakalatnama on behalf of the principals. To list the matter again on 29th of July 2024. in the meantime, no, yeah.
May please, your lordship, kindly see office note dated 15/6/2024, lordship. Note dated 15/6/2024, lordship.
Service not complete. Service not complete list the matter after completion of service. Team.
Lordship, we may allow to take a fresh step upon the response number.
What?
Response number 2, 22, 24, and 25, lordship.
What do you want to do?
Take fresh step, lordship. Lordship, we may allow to take fresh step upon the response number 2, 22, 24, and 25, lordship.
What do you want?
Fresh steps, lordship.
Best steps. Let us wait. It's a new matter, 2022. Another 10 years. Okay. You want to take fresh steps? On?
Response 2, 22, 24, and 25.
What about 13 and 17?
The address in respect of.
Why do you want 2, 23, 33, 23, 24, and 25? Those steps have been received. Oh, you have not taken steps. Why? Please strike out their names. You don't require them. Why haven't you taken steps?
Sorry, lordship.
Why? Better. Earlier order is better for you. Okay.
Party,
You immediately take steps. I won't record it. Go. Fresh steps. You have not taken steps. What is the fresh steps?
may I please, your lordship, my lord, I have already.
Yes, you have also not taken steps
I have
upon
taken.
response number 2. When?
Hello.
Today morning.
No, my lord, yesterday, my lord. Yesterday, my lord.
Yesterday, very early. What is this IA for?
But IA for continuation of delay, my lord, 56 days.
How many days?
56 days, my lord.
What is this arbitration appeal?
Yes, my lord.
37.
34, my lord.
Huh? What? Huh?
Yes, my lord. 37, my lord.
Madam, you are appearing for? What about the others?
Yes,
Who has got the award in their favor?
my lord, respondent number 2, my lord. 1 and 2, my lord.
1 and 2.
Yes, my lord.
And you have not taken steps. The counsel appearing on behalf of the applicant is directed to forthwith take fresh steps upon the response number 1, 2, and 3 by way of registered as well as usual.
My lord, 1, 3. Yes, my lord. Completed, my lord.
Huh?
1, 3 completed, my lord, except 2, my lord. And 4 is already appeared by learned friend.
2.
Only 2 is not, my lord, completed.
2, why is it required? The branch manager.
Yes, my lord. And I have already taken, my lord, the step.
And you have not taken steps upon 2.
Yes, my lord, I have taken already. Yes, sir.
Why did you take steps so late? And nobody has appeared. 1 and 3?
Yes, my lord, not appeared till date, but service is completed, my lord.
Where, which order?
My lord.
Unsigned AD kind signed by some Amita Rani Nath. Who is Amita Rani Nath? Can't happen like this. No, you take fresh steps.
My lord, I will take.
The counsel appearing on behalf of the applicant submits that he has taken fresh steps has already taken steps on
On my lord,
25/6/2024 before the registry upon the respond number 2. Gustav. Both I have also taken note of that the respond number 1 and 3 have not appeared. Under such circumstances, ends of justice, this court directs the appellant to the applicant to take fresh by way of registered as well as usual. It's the matter again on 12th of August 2024.
Obliged,
The
ma'am.
steps be taken within 3 days.
Obliged.
No steps.
So, my lord, I took the step on 23/6/23, my lord, but that was not proper. That remark is domestic, my lord. But morning one advocate was sitting, my lord. She was ready to appear, my lord, but now she is not here, my lord. Maybe maybe fixed on the Friday, my lord. I inform her.
Why?
Because, my lord, they are ready to appear on the behalf of the respondent, my lord.
Who's the respondent?
Respondent, my lord, advocate who was appeared before the my lord, a railway tribunal, my lord. Because
So
agency
this
is Nepal,
court,
my lord.
so you mean to say this court should suit its quotas on the basis of what she or he thinks?
So, my lord, that is, I'm not
I'm
saying
not
that.
concerned with that.
Then, my
You
lord,
have
I'm
not
saying-
taken steps, take fresh steps.
Yes, my lord.
Counsel, it is seen from the office note dated 18/6/2024 that no steps have been taken upon the respondent. Appellant is directed to take fresh steps upon the respondent by way of registered as well as usual within 3 days. List the matter again on 9th of September.
Must oblige, my lord.
Service is complete in this matter, lordship, but the LCR is not received.
Service complete, however, the LCR has not been received, the registry shall take appropriate steps for requisitioning. Yeah, and thereupon list the matter for hearing in the usual course.
33, 34.
Liberty, however, is given to the parties to file application for early hearing if upon what is this?
If it explaining the delay was,
Oh, then
I have filed.
you have a good ground. What do you say?
Was suffering from jaundice, so it's not.
Because the last time I was about to dismiss it, I gave you one further chance, didn't it? And now also his affidavit is not so. Much is the delay?
11 days, lordship. 11 days, lordship.
11 days. Ah. Then also, there is not a single whisper about reasons. Now you have given some reasons, ABCD something. Where is that affidavit?
Lordship, case 10, lordship.
Huh?
Case 10.
Good goal affidavit. তো কবচোন এইবোৰক মানে আমি কাম নেকি কওকচোন start being out there before the trial court মানে কি কয় এইটো ৰেজিষ্ট্ৰিত বহা আৰম্ভ কৰিম নেকি where is that affidavit বিচাৰি নাপায় অকণ চিৰিয়েলি এখন নবনাই
Lordship, in the CRP, lordship.
কাম হ'ব কোনে বিচাৰি ফুৰিব এইটো
Higher 2699, lordship.
The counsel appearing on behalf of the petitioner applicant submits that an additional affidavit has been filed. However, from a perusal of the records of IAC number 67/2022,
Yes, lordship, but we have filed it in IA 2699 of 22.
what is that?
That is a delay.
It's the delay condonation.
Yes, Lordship.
You're appearing for everybody. Okay. Lekho. This is an application file. IAC 2699. Is that the application?
99, Lordship.
For condoning the delay of 11 days in filing the civil revision petition and 15 of the Code of Civil Procedure for setting aside the order dated 4/5/2022 passed in title execution case number 4/2016 by the Court of the Learned Munsif, North Salmara, Abhayapuri. This court, by an order dated 22/3/2024, directed the granted liberty to the applicants to file an application, additional affidavit, taking into account that the application for condonation of delay was bereft of particulars. In pursuance to that, an additional affidavit has been filed on 6th of May 2024. For a perusal of the said affidavit, it transpires that the cause of delay in filing the accompanying revision application is sufficient, and accordingly the delay of 11 days is condoned. I stands disposed. Now let us take up your revision application. Where is that? And what is the other IA for? That 11 days. So that is being done.
That is,
No, that restoration is which one?
RSA, Lordship.
2699.
No, 2699 is delay in CRP, Lordship.
CRP.
Yes.
So that I have condoned.
Yes,
So
Lord.
that goes. Now what is this? There is another RSA also.
Yes, Lord.
RSA for what? For what? Restoration. Which was dismissed for default. Why? Huh? 3 times. Okay. 1 lakh. 1 lakh minimum.
No, Lordship.
3 times. 1 lakh.
No, Lordship. 1 lakh is too heavy, Lordship.
No. It is not heavy. You do one thing. We'll have it after vacation. In the meantime, apply for loan.
Pardon, Lordship.
3 times dismissed for default. And then also you have the audacity to again appear before the court.
The-
Season of giving awards is over. Otherwise, I would have recommended your name. That Mr. Sri Sharma has the audacity to appear even after dismissal. That too of 2001 matter. Second appeal conduction. Let us dismiss the second appeal once for all. Matter over then. We can restore and dismiss. What is the second appeal? Whether the learned Ayak misconstrued the point of law that Hindu women married prior to the enactment of Hindu Succession Act are not entitled to inherit interstate property. What is the point on the Hindu Succession Act?
Lordship. Of the copy of the RSA.
What? And you are asking for condone what the restoration and you don't have a copy.
I was in school when this.
Huh?
When this RSA was filed, I was in school, Lordship.
That is why, na? Now you want earlier the award would have been state award. Now you want a national award. Something like that. Otherwise, why? Tell me. First of all, you have the audacity to file 3 times dismiss and then again come over 2001. And now, when I ask you about the matter, you say I was in the school when the RSA was filed. I may very well say, how can I decide I was not born when the matter was, the suit was filed? Then,
Lordship. We'll get a certified copy and go through it, Lordship.
এটা হৈ গৈছে আজি enough. This matter is too troublesome for me. CRP to restore কৰিলো না এইটো. Yes.
Please, well.
He has no contact. Okay. Logo to record. Goodness. Tell me, why should the lower court record be called for?
In fact, I've gone through the office note 15 to 2024. Respond number 1 to my lord service is not complete.
You are there? No. Are you the respondent in the appeal, in the suit?
Already,
Okay, fantastic. I hope the instant appeal was filed being aggrieved by the non-granting of an ad interim temporary injunction, ex parte temporary injunction, by the court of the, being aggrieved by the non-granting of an ex parte ad interim temporary injunction by the court of the Civil Judge Senior Division number 1, Kamrup Metro at Guwahati, by its order dated 26/9/2023 in Mizze case number 940/2023, arising out of title suit number 580/2023. Full stop. It has been duly informed that the respondents in the suit, the defendants in the suit have duly appeared. Okay, now you know. There is no stay. When is the next? What stay? There is no stay here. No stay. Stay. There is no stay. Till return, the appellant shall not be dispossessed. That's an injunction, not a stay. When is the next date?
so it's done, my lord, 28/6/2024.
Huh?
28/6, my lord.
Okay. It has been brought to the attention of this court. It is now being brought to the attention of this court that the respondents, who are the defendants in the suit, are in know of the pendency of the suit, being title suit number 580/2023, and the next date is fixed on 28/6/2023. Under such circumstances, this court would not like to continue a parallel proceedings before this court, in this parallel injunction proceedings. Accordingly, this court disposes of the instant appeal, thereby directing the parties to maintain status quo as regards the Schedule B, as regards possession of the Schedule B flat, till the disposal of Mizze case number 940/2023. Full stop. The records which have been called for by this court be forthwith returned to the Court of the Civil Judge, Senior Division Number 1, Kamrup Metro at Guwahati. Full stop. It is made clear that the learned trial court shall, upon receipt of the records, take due measures for early disposal of the injunction proceedings and without being influenced by the order being passed by this court in the instant appeal proceedings. Appeal stands disposed. I closed in view of the order passed.
Does that, my lord, the order next date, my lord, have stated as 23, my lord?
What?
Here, my lord. Should have stated the next date as 23, my
It is when?
28, 06, 2024.
They also know. Where you put it? Go and put it 23.
Deeply obliged. 36.
Yes.
Service upon the sole respondent is not complete. Report has come that he stays outside the state.
Then,
Then he was
okay,
serving
you
in
want to
Delhi.
take fresh steps?
First step, as well as we may have to give a paper publication also, because he's now residing.
Then
in
you
Guwahati.
file an application for substituted service. Mr. B.K. Bhagwati, learned counsel submits that he may be permitted to file an application. He would like to take substituted service upon the respondent number 1.
Sole respondent.
Upon the, no, there are 2.
Let's see, respondent number 1.
The sole respondent not found. Respondent lives outside. Respondent number 2 addressee lived. Who is that respondent number 2?
That's my own brother. Actually, he was residing in Delhi. Thereafter, he has come back to Guwahati.
No, who is respondent number 2?
Respondent number 2,
I can't see this here, concern.
only one respondent. Let's see.
Alle sole respondent लेके बोलो.
Only one respondent.
Huh?
Only one respondent. Santaram Prabha.
Whether- हाँ, को আছে? Respondent number 2 को पाहिले. Super respondent number 2 is sole respondent number 2. Mr. B.K. Bhagwati, learned counsel submits that as the respondent is outside the state, he would like to take substituted service. It is the opinion of this court that if the petitioner appellants want to take service by way of wants to effect substituted service, there is a requirement of filing an application. The B.K. Bhagwati submits that by 15th of July, such application will be filed. List the matter immediately up thereafter. Who is respondent number 5? Who is 5? It is very difficult to file. Registry manok mati bosu. Find out this thing is also difficult. What is this? Where do I find out this? Oh, so now, put more bisari pao. Where do I find this? Petition or copy for this? I know any page number 7 will be. Yes, who is this? Respondent number 5 is Santoshi Bewa. A performer respondent. Okay. The office note shows that the service upon the respond numbers 1 to 4 is complete. And the learned counsel duly appears on the behalf of the said respondents. The learned counsel for the respondent numbers 1 to 4 further draws the attention of the score to the respondent number 5 and also draws the attention of the court to the impugned judgment and decree, wherein the respondent number 5 has been shown as being substituted by two of her legal representatives. So, taking into account the above, the appeal has been filed against the dead person. The name of the respondent number 5 is struck off. Full stop. It is also seen that the service upon the respondent numbers, the LCR has been duly received. List the matter for hearing in a usual course. Liberty, however, is given to parties for filing applications for early hearing of the matter. What is this FAO business?
I has been filed for deleting the names of the
FAO for what?
performer respondents. This for
Okay, about that. What is this FAO business?
FAO for injunction also.
You got an injunction.
Yes. She got an injunction, I am for the defendant.
Then
So the plaintiff filed a suit for the apportionment of the amount, 41 lakhs and 15 lakhs. So the learned trial court has passed an order giving a blanket ban to this release of that amount, the total amount. So our contention is that since we are one of the legal heirs, so at least 50% amount can be some sort of injunction can be there with regard to 50% amount, but the learned trial court has given injunction with regard to the total amount. So this is
Then?
basic prayer in this FAO law.
you are a legal representative. Who is she?
She is another legal heir.
How are both different?
The cousin,
Whose money?
3 sisters.
So you are fighting amongst your sisters.
Yes.
Yes. So everybody, there are 3 sisters,
3 sisters.
and everybody is entitled to how much?
No, Lordship, 3 sisters. The amount belongs to one sister, and she died issueless. Now it's a fight between the legal heirs of other 2 sisters.
Understood. So
Yes.
50-50.
50-50. Actually, we are on that 50-50.
So you want 50%.
Exactly, Lordship. There is no issue with regard to that.
Take it. So,
We are not on that.
so we pass an order that both of you are liberty to ask for the money.
50%. No, this will serve the purpose.
Huh?
This will serve the purpose. Basically, we are on that claim amount. It's the intent.
Then who asked for the injunction?
Yes, she asked for the injunction.
Why did you ask for the injunction? Huh?
This is the decision of the court.
Why? So it will, interest will accumulate. Entire amount. Oh, therefore, oh, you are not entitled to. So you don't want him to get anything.
Yes.
No, but he's a, if you say that he's not a nominee. What did the trial court decide?
67 Lordship.
The rule of nominee in the light of the provision of Anyway, you can't stop him from getting his 50%. Okay, let him get the 50%, 50%, let it be kept. No, that you have raised the dispute, isn't it? No, 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 no. You have got an injunction. We have to respect that injunction. That 50% be kept. What do you say, Mr. Chaudhary? You get the 50%. And less 50, let it be subject to the outcome of the suit. You got an injunction. Why? There's no quarrel that he is entitled to 50%. How many are there?
One, two. Three
What
persons
people?
from
No, no, there
one
was only one sister was there.
here in this FAO law.
Huh?
1, 2, and 3. 1, 2, 3. We are the appellants. We are claiming the share of my mother.
So that is it. Who is the nominee?
Is Nilotpal Bhattacharya. Nilotpal Bhattacharya.
So he is the nominee.
Yes.
So then also he is entitled to 50%. Not
One, two,
all
and
three of them.
1, 2, 3. These three.
However they spend, that is their lookout.
Yes.
The appellants are entitled to 50%. We modify the order to only to that extent that 50% he will be able to take. Remaining will remain as it is till the disposal of the state. You have got an injunction. Why? Okay, then you give you undertake to give the loss which he is going to occasion. Are you going to give it? No, you have to give you can't have an injunction like that. You have to give the interest, that whatever interest it accrues on this amount at the rate of 18% per annum, at the end of the trial, you will give it to him. To him. Then question of interest would not be there. No, I'm not saying that. So rest of the 50% will be remain. Only 50% will be given.
Yes.
The court could not have given the entire thing. The entire thing. Because it is only 50% who is not entitled. Isn't it? No, suit will remain. For the interest you are going to pay to him if he wins the entire case. Huh? Hello, we do one thing, we'll have it next reopening.
On the reopening day also.
Madam, only thing is, I will continue with the injunction with an indemnity bond being submitted by you before the trial court, that you would be, in the circumstance he is entitled to any amount, he will be entitled to interest on the said amount at 9% till the disposal. Okay, list the matter again on 24th of July 2024. In the meantime, Ms. R. Chaudhary, learned counsel, appearing on behalf of the respondent shall obtain instruction, respondent number 1 shall obtain instruction as to whether the 50% of the amount which have been restrained by the learned trial court by the impugned order can be allowed to be released to the, and as to whether the respondent number 1 would have any objection in the release of 50% of the amount which had been restrained by the learned trial court by the impugned order be released to the appellants. It's the matter again on list the matter.
Nine.
Yes, what is this? It has been issued to the. Huh? What is this IA for?
I for condonation, my lord.
How much?
199 days.
Okay, Mr. So K. Sharma. K. Quilty appearing on behalf of the respondent submits that he may be granted 4 weeks' time for filing reply. Accordingly, list the matter on 28th of August 2024. And the reply be filed by 22nd of August 2000.
Oblige.
What is this?
Lordship review petition.
Yes, Mr. P. Sharma. Any matters with this review application? What have I done now?
The respondent number 7, Lordship.
Which is the order?
Order is page 18. 18. Page 25 is the last.
What is the matter about?
It was a writ petition regarding fishery. Second class fishery. And Lordship was pleased to set aside an order dated 29/6/2020 passed by the circle officer, holding that the respondent number 7 and 8 violated the earlier terms and conditions of the settlement. Now, respondent number 7 is before Lordship.
Why?
Lordship, the order dated 29/6/20.
Did you participate in the trial in the earlier proceedings?
Yes, yes.
Then what happened?
Affidavit is also there. Affidavit is also there.
Then
Only one point, most probably it has been overlooked, Lordship. Page 25, my Lordship, kindly come, page 25, last part.
yes.
And further to that, Lordship. Even assuming that the order had reacted that the respondent
Assuming-
number 7 and 8 to be granted.
Page 25.
Page 25.
A perusal of the said order dated it reveals that this directed the settlement. But it is the response. It will respond. It order do not in. Meaning that the order had. Conditions of the permission, which admittedly had. What is wrong?
Lordship, it is regarding now writ petition page 37, Lordship. The settlement
What
order
page?
is dated 20.
What page 37?
Writ petition, Lordship.
We don't have page 37 here.
Writ petition.
Parties are represent, the matter comes up for consideration of the present. Application has proposed. Then what happened?
This order dated 29/6/2020 is
Am I appearing on
Next,
behalf
sir.
of the official? Yes, what is this?
that's why Lordship, page 20.
So now this is the, Mr. P. Sharma, this is a case of cost,
Let me point out, Lordship.
huge amounts. Because one, the fishery department is going under loss and they are paying from the neck to Mr. P. Sharma because of your unnecessary litigations.
It is not unnecessary, Lordship. Lordship will, I will
One,
confess,
two,
Lordship.
three.
This is perhaps overlooking, it is overlooked or otherwise. It
Then
was
why
not-
didn't the first trial, the writ appellate court do anything? You, at the end, okay, let me file a review. What is
Whereas
this?
ergo, this point was raised there, that
What did you challenge? Who is the petitioner? You were there? Yes, what did you challenge? Was permitted to catch fish from the second class fishery by the order dated demand passed by the respondent number 5. The permission so granted to the respondent was subject to certain conditions. The petitioner shall abide Pay annual revenue, so and so, so. And-
Second class difference, my lord,
Oh, Minister of Fishery, you got too much money.
Lordship, their
No,
petition was
no,
also
cost.
by MLA.
Huh?
Their petition was also forwarded by MLA. I am not on that.
You got it
I am not on that.
because of
Lordship.
Ministry of Revenue.
No, I am not on that. Lordship.
Nothing doing. Yeah.
I am not on that. Lordship.
Then what are
My
you on?
point only, this order dated 29/6/20, it is there that the says that this earlier settlement order dated 23/9/2022, terms and condition of that was violated. My settlement order is not dated 29/2002. It is only for the respondent number 8. My was earlier, so this part of only I want. My settlement order is also annexed with the affidavit in opposition.
What is your, how did you get it?
By a settlement order, it is of
How?
2001.
2001, how can you run it? For long? We are in
It is
2024.
it actually, as per this rule 14, this settlement is unlike this first class 60%. It is 40% is little different. Rule 14 says, Lordship, yes, in the Kasar district. This is in Kasar district,
these are second class difference, small water.
small water bodies.
Adjacent areas. By mutation, we are having the,
Yes.
theta.
So from our grandfather times, it is going on. And there are,
These are government fisheries.
these are government fitters, government.
Government fisheries are given
It's
in
like wetland.
perpetuity. How?
Not an inheritance, my lord, that
And these are left open, Lordship. These are not that fishery community persons has to be given this. If the adjoint landowners are given this settlement by recording their name in the Chita, so it continues. It continues. So these are all.
You did not get it on that basis. You got it because you are unemployed. And
Yes, yes.
Ministry of Fisheries
Yes,
wrote
yes.
it. Daily basis stopped. That is the main cause of heartburning of a lot of people. Daily basis is the thing by which a lot of other people make other profits. Daily basis. Which one? Who? Okay. Very good, very good. So did you pay fresh assessment of government revenue?
Yes, every time I am paying. These are not on record in this case, Lordship. I was paying every year.
That's the circle officer's report. Also mentioned the respondent were paying government revenue as per the old rate. 875 and 500 and 1000 and so only to the, in the current year as appears from the Xerox copy of the revenue receipts. No case.
In this report is also.
Have you
Lordship,
cancelled them? We cancelled it.
Yes, yes. My humble
We
submission.
do
is
one
this.
thing.
My
Let
settlement.
me keep this review petition pending for next 10 years. Then in the meantime, you do whatever you feel.
Lordship, I may be allowed to make my submission. I am
No.
not on also Lordship as in paragraph 10 in the.
Taking
order
into
Lordship.
account that further hearing would be required for the purpose of issuance of to consider as to whether any notice can be issued in the instant proceedings. This court fixes the matter to be listed after vacations on 2nd of August 2020. Is by this way 10 years, 24, 34. Then we'll see. And he can't go anywhere. Review petition
I
is
have only
pending.
simple point, Lordship. My settlement order is not.
And he has stopped it from there also. He can't go in appeal also. Appeal is gone.
My settlement order was not. There is nothing. in
You
the-
got it through Ministry of Fishery.
He has also got through MLA Lordship. Yes, it is in the petition. Obliged.
Yes, what is wrong, Mr. Sahiwala?
No, my lord, just one simple, my lord, when the order was passed, no, my lord, no time frame was given, only that is the limited prayer.
What?
No time frame was given, my lord.
Which one?
My lord, at page number, my lord. 24, my lord. Para 13, my lord. Under the circumstances, this court directs the respondent 1 and 2 carry out the necessary inquiries and investigation in respect to the document which was submitted to respondent 5. This court opines the direct that in during the inquiry, any material comes to light which would show that respondent 5 had violated the code of integrity. The authority, after giving the opportunity of hearing of the respondent 5, deal with
Oh, that matter.
my lord.
So to make an investigation and all
Madam.
these things.
Only time frame was not given. That is the only limited prayer.
Court directs the respondent number 1 to carry out the net. Who is respondent number 1 and 2? You do one thing.
Well,
Mr. Esbora, serve a copy. Mr. Esbora was appearing.
Well.
Serve a copy to him and the name. We get this done.
Well.
After vacation.
Well.
Sir. Mr. A.K. Sahiwala, the learned counsel is directed to serve a copy of the Esbora, the learned counsel, appearing on behalf of the respondent number 2. And his name may be duly shown in the cause list. List the matter again on 26th of July.
I pray for some other day, my lord.
Yes,
My lord,
give you.
either on 17th or thereafter, my lord.
17th is closed. You
17th
want to
of,
come?
17th of June, my lord.
June
Oh,
is,
sorry, my
July is closed.
or July. 30th, my lord.
Mr. Sahiwala, you always have the opportunity of doing your matter pleasurably from your home.
Hello.
Give you here.
Hello.
Let it be as it is.
That is very difficult before your honor to do by VC. Because
Huh?
very difficult to do by VC before your honor.
Why?
Practically, when somebody is there, no, it becomes very easy to show the documents. My lord.
No, I understand. No, what I'm saying is the order which I propose to pass, I would not do so. So I will just point it out to Mr. Bora so that Mr. Bora will say that he will do and I'll record that. This is how it is done. Because if I issue this notice, a missed case cannot be filed in a disposed of matter. So your application has to be dismissed. So that is why I wanted Mr. Bora's name is there. Mr. Bora comes out there. So I even don't require you. I remember what to say.
Deeply obliged.
Hearing. No, hearing? Who wants to do hearing at the end of this? Hearing. Did I fix any hearing? How did this matter come up? No. This is a matter after vacations. I never fixed all these matters. No hearing business.
It's the matter for hearing, my lord. The
Huh?
time is very short. Within that 20 minutes, it will be difficult. LCR has already received by the court, my lord. It's
Which one?
appeal,
This one?
Matrimonial appeal.
I fixed it. I never fix it. Who has done it by order? By order consent kune korche?
We have filed that.
Okay,
Before
not
the
give.
division bench, actually, my lord.
Huh?
Division bench. Then roster, it has changed, my lord.
Fine.
All matrimonial appeal now will be taken up by the single bench.
Who court? Well,
It's tomorrow, it will district judge.
it's a DB matter. It's a single bench matter. None appears on behalf of the appellant on call. G. Chaudhary Dharani appears on here, taking into account that there is a matter of further chance in leaves the matter after summer vacation. Then, nowadays these matters come up if it is not a family court.
Yes. Yes.
Then it will be DB.
This is district judge.
It is district.
So therefore, no. And furthermore, not before me, because I did not give you any permission. You go before that court.
Not family court.
Uh,
Judgment not
Take,
ready.
so, लिखी दियो, list the matter before any other bench and not before me.
After revision, my.
I cannot list the matter of any other bench. Any other bench will do. Because I am very particular. No mention can be made of a hearing matter, and if some mention happens out there and if matter comes up on by order, let that court take it. I am not going to take it.
My lord, that is for order, mention.
This is for orders.
Not
This
for
cannot be. How did you bring it for orders? It has come up for hearing today.
Yes, today listed for hearing, but we have mentioned for order.
Why?
Because my lord, many.
When this court had already passed an order to be listed after the summer vacations, why did you
Yes.
mention the matter? You were not
We
very
have-
much appearing on that earlier date.
Recently engaged in the case. my
Whatever may be. None appeared on the earlier occasion when the matter
that-
came up
that's right,
before
my
this court. On 15/6/2023, none has appeared on behalf of anybody. Mr. Chaudhary had only appeared. However, for the ends of justice, I did not dismiss for default. Then the matter again has come like this, and you make a mention 26/2024, asking it to be fixed on 26. Go before that court. Orders. Cannot come up for orders now when the matter has been already fixed for hearing. Unless you file an IA, since the recorded matter be listed for hearing on so and so, you cannot fix and bring the matter back to tomorrow. Tell you after admission, can you make the matter again? Okay, list it for motion. Not possible. List the matter before any other court, not before me.
lord. Oh.